Hello, my name is Mike Ryan. The name of the show is Jury Duty and Make a Difference on BNN, the show that should answer all your questions regarding the one-day, one-trial jury system. Our guest today is Professor Alan Rogers from Boston College. Welcome, Professor.
Thank you very much.
Pleasure
to be here.
Thank you for coming here. Professor Rogers is a graduate of the University of California at Santa Barbara and also later earned his doctorate at the same university. He has been at Boston College for 40 years, and he is a prolific lecturer and writer on legal history, and especially the United States Constitution. And today we'd like to talk about jury trials, but also he wrote an article about the fight for women to sit on juries in Massachusetts. So we'd like to start off today with the Boston Massacre trials. I mean, we've all, somewhere in school, we've learned about the Boston Massacre, but what were the facts behind it?
Well, the facts, as you know, first the context before the facts came into the court. The context was, it was obviously a tumultuous time, the run-up to the revolution. It wasn't so described, but by hindsight, we know, yes, in fact, that was what was going on. There was violence in the streets. A particular person who was a loyalist, Richardson, there was some shooting. There was a mob scene every once in a while, soldiers and would-be workers who were uncomfortable with the fact that soldiers were taking the jobs of unemployed Bostonians, and so that in politics. So it was quite a tumultuous scene. The massacre, of course, May 5th, March 5th, yes, 1770. A mob gathers, taunts the soldiers who had been reinforced a few minutes earlier, standing in front of the counting house. And while witnesses differ as to exactly what happened, shots were fired, Americans fell to the ground, including Crispus Attucks, most notably, and trial ensued.
So there were two jury trials, correct?
Yes.
The first one was against the British captain.
Captain Preston, right.
Preston, and I guess the legal term was Rex versus Preston, but
yes.
Rex means
king.
The king.
Yes.
And who was the lead counsel for Captain Preston?
Yes, John Adams.
And John Adams. Now, was that a popular thing to do at that time?
Well, there's some controversy about that. In Adams' memory, and 30 years old at the time that he delivered this. I mean, the memory was 30 years old, so one wants to look at it carefully. He spoke of rising to the cause, and he thought that since no one else was willing, and he didn't want the trial to go to the radicals, though he himself was a radical, certainly, he thought others were more firebrand than he.
Like his cousin?
Yes, like his cousin, Sam. So he felt pressured, in other words, and I think this is an honest evaluation, he felt pressured to stand up for the rule of law. Certainly he wasn't on the side of the British, certainly, I mean, he would have rolled over in his grave now and many times over if that accusation had been made, but he thought it was time to stand up for the law, to show that the Americans were not a rabble, that they indeed had just grievances and they were going to press those grievances through the law and eventually by armed force. But therefore he stood up one way or another, whatever his recollection.
So the Preston trial lasted 6 days. It was the longest murder trial at that time in Massachusetts?
Yes, murder trials ordinarily took a day. Sometimes it would spill over to the second day, but they were done quickly. Hillary Zobel, who wrote the book, of course, on the Boston Massacre, always lamented the fact that it took so darn long now, 20th century, to run a murder trial or any sort of trial. In the good old days, it was done by the numbers and done quickly, and he thought the verdicts were just as good, just as just in the 18th century as they were in the 20th. I'm not so sure about that. But
was this the first time jury was sequestered?
Yes, the first time juries were sequestered, yes. And And it was not at all a common, either then, at the time it certainly was uncommon, but even subsequently not a common thing to do. Much more routine now to do that, but yes, it was a novelty at the time.
In your book, Murder and Death and the Death Penalty in Massachusetts, you mentioned that one of the junior judges mentioned that jurors should be convinced beyond reasonable doubt, and that may have been the first time that was uttered.
That phrase was used, that's correct. And that certainly is a landmark. I mean, certainly is a mark not only in legal history, but in the shift in culture. Certainly God and country, one pled God and country, meaning to a jury trial. So God wasn't completely absent from the lexicon of jurors and lawyers. But to say that the jurors had to be convinced beyond a reasonable doubt indicated that the good old days of Puritanism and deferring to religion as a sort of marker of what was good and true had passed. And the idea was now we're in an age of reason, and so that is the way in which jurors should measure guilt or innocence.
So Captain Preston was acquitted by a jury.
Yes.
And a month later, the 8 soldiers were tried.
Again. John Adams as their counsel.
John Adams. And not one of those jurors came from Boston.
No, right.
Which is kind of interesting.
Yes. Of course, there were a number of jurors who were paraded in front. Jurors, of course, were selected differently then. They were selected by town meeting. And town meeting was eager, of course, to place more radicals on the jury than was Adams or pretty much anyone else. So yes, they were struck. As in Preston's trial, of course, that meant they had to go out into because they had gone through, Adams had gone through, and the defense, Payne, had gone, Robert Payne, had gone through a number of jurors, and therefore they went out into the street to round up 5 more needed to make the 12 good men and true. So not surprising that there weren't Bostonians. Surprising that the 5 that were rounded up in Preston's trial were known loyalists, or at least leaned in that direction, so that it wasn't quite the impartial jury, I suppose, that the defense would have liked. It made perhaps Adams's job a bit easier.
So of the 6 of the 8 jurors were found not guilty of murder, and 2 were convicted of manslaughter.
Right.
So in lieu of being imprisoned or tortured, they claimed
right of clergy.
And what was that?
Clergy, right of clergy is from England, and the practice was that if you could recite a particular verse from the Bible, then it was called the hanging verse, colloquially. Then you could plead right of clergy and therefore not be put to death, but in fact punish the soldiers with the branding on the thumb.
So 6 of the 8 were found not guilty. 2 were convicted of manslaughter, branded, but then they were freed.
Yes.
So would you think in the long life of John Adams, who I believe was 94 when he passed, was this his finest hour?
Well,
he looked fondly.
Yes, his finest legal hour, yes. No question. I mean, he did a masterful job. He was, after all, quite a good lawyer. This wasn't his first time out. He had tried criminal cases before. He writes in his diary of a case that he tried of a man indicted and on trial for rape, which was a capital crime at the time. And Adams was so pleased with the result, that is to say, he was able to convince the jury that this man, in fact, should go free. And he then followed the man, after the trial, he followed the man to his cell, and the man, with tears in his eyes, embraced Adams, and Adams just felt like his whole life had been vindicated and so on. So he was a skilled lawyer. He was a trained lawyer. He had seen it all, I think, by 1770. And I think he was happy that he had stood up for the law, and that the revolution was on its way. he was certainly committed to that goal. So both goals, the law and the revolution.
Let's go a little farther ahead into the 20th century, and would you say that the Sacco and Vanzetti trial was probably the most controversial trial of recent times?
Well, we've had a lot of controversial trials since. Certainly it was one of those, and certainly in the sense that it captured international attention, attention across the United States and literally around the world. And that it was so deeply politicized. I think that's what gave it its panache, the fact that everyone still recognizes it as a landmark trial, yes.
And they, Sacco and Vanzetti were accused of robbery and shooting 2 people to death. Mm-hmm. And they were tried in 1920, but they were not executed till 1927,
yes.
Which seems like a very long time even by today's standards.
Well, yes, there were a number of appeals, as most people are familiar, and the appeals, as then as now, moved slowly, and there was, and they were controversial, so it took a while. What was interesting was that in your book that Vanzetti had already been convicted of attempted armed robbery a few months prior to the Braintree bank robbery, and it was the same judge who sentenced him, who was part of the Sacco trial as well. Yes, an unusual phenomenon. The record doesn't show that he necessarily asked for that follow-up assignment, but it certainly seems likely that he did, and that otherwise he would have been in a rotation that would have taken him out of that, but it seems like he wanted it.
What was interesting in your book, too, that you said during jury deliberations, after the trial was over, that the foreman of the jury brought in gun shells that supposedly were the same that Vanzetti had in his gun?
Yes. Well, one can imagine that that would not be permitted today or any time in the modern era. But yes, he did, and of course that was a cause for some to say that the trial was badly done, that it was that jurors were swept up in the radicalism of the time and were eager and bound to convict when the evidence didn't demonstrate that at all.
And similarly to the massacre trial, they had a tough time getting in different jurors, correct?
Yes. The first batch of jurors brought in to Thayer was 500, and they, out of that number, had 7 only. They brought in another several hundred and drew a blank, and therefore, again, the sheriff was ordered
the highways and the byways
to go out into the streets and round up 5 more people, which they did, and swore them the same morning they brought them in. So yes, it was very much like the massacre trial. Only I think these jurors were not as committed to one cause or other as perhaps the ones were rounded up for the massacre trial.
It was interesting. I didn't realize the trial was in Dedham, which is, of course, in Norfolk County, but at that time it was paired with Plymouth County.
Yes.
The district attorney's office was Norfolk and Plymouth.
Yes, right.
Definitely different. Now, there was a point post-trial that there was from the defense that there was new evidence that that said that they did not commit the crime, and that was appealed. And
yes, didn't go much of anywhere. I mean, it was the new evidence, of course, came from someone who was already himself convicted of murder, and so the idea was, well, he was looking for a way out, and the appeal failed. Yes, I mean, I think justly so.
Now, eventually. The governor at the time, Governor Alvin T. Fuller, the founder of the Miracle Mile, I believe, had an advisory commission post-verdict. Has that ever happened in your research?
No, that was a unique part of the trial as well, or the aftermath of the trial. Yeah. I suppose it was looking for, some justification, some way to lift the shadow that was over the mass bar at the time in the judicial system, to lift that shadow. It didn't work. It wasn't until quite some time later. In fact, it wasn't until, I would say, till 1975, when Justice Toro and his compatriots hinted that they were going to abolish capital punishment in Massachusetts. And I believe it was Justice Wilkins who at the time referred to the Sacco-Vanzetti trial and said, our move now will lift that cloud that's hanging over us, that has hung over the mass judicial system.
You said in your book that whether Sacco and Vanzetti were guilty or not is an elusive goal, but you also said because of that trial, it opened the doors to the abolition of the death penalty.
Yes. Yeah, it opened the doors. I mean, of the 5 or several hundred jurors who were challenged for cause, almost to a man, they said no, they couldn't be on a jury in which someone was going to be put to death. And I think that was the beginning. I mean, not necessarily the idea that I credit Sarah Ehrman for pushing, for becoming the face and the energy of the anti-capitalist, to abolish capital punishment. But I think it was there, and and Ehrman was one of the people who helped pull that together, that energy against capital punishment, and eventually succeed.
And you wrote an article a few years ago about the fight for women to be in the jury box, and I think a lot of people felt at the time when women were allowed to vote, which was the 19th Amendment, and it took place in 1920, that women could sit on a jury, but that's not what the amendment entailed, correct?
No, it wasn't what the amendment entailed, though a number of states interpreted it as such. And certainly during the campaign for women's right to vote, it was often mentioned in other states, and certainly here in Massachusetts, that right to vote included, though it wasn't specifically included, but it was presumed to be included, the right to sit on juries. I mean, that was how it operated normally. That is to say, when an immigrant came into Massachusetts and was here some time, and when he established residency and became a citizen and had the right to vote, then it followed that he was subject to be called for jury service. So it wasn't far-fetched that women thought, well, yes, that's the way it'll work for us. Of course, no.
And there were women on a jury in Wyoming in 1870,
yes,
when it was a territory.
In the 1880s, yes, right. And a number of western states in particular granted women the right to sit on juries early.
So it took 30 years from the passage of the 19th Amendment for women to be called into the jury. What were some of the reasons behind?
Well, the same reasons that were used in opposition to granting women the right to vote were behind the idea that women shouldn't sit on juries. It would destroy their femininity. It would tear up the family. They were too soft, too sentimental to sit on juries. Or oppositely, sitting on a jury would harden women. They wouldn't be the same sweet, lovely people that we know them to be now, but they would be tough. They would have, I think Frank Grinnell used the phrase, they would have the iron in their soul, right? And nobody wanted that. Ugh, that was terrible. Jury service was a man's job, and it was a dirty job, but someone had to do it, and the men were obviously the choice, since they had the power.
Wasn't one of the reasons that they'd have to build additional bathroom facilities in the courthouses?
Yes, right, there was that. That was used as an excuse. Yes, as though that were an insurmountable, yeah. And
there were several studies, I guess, through the 20s and the 30s, rejecting the fact that the women shouldn't go into the jury pool. Notably, the League of Women Voters fought for it. Jenny Leutman Barron, who later became a Superior Court judge, led the fight. But finally, there was a legislator from Needham who led the fight.
Leslie Cutler, yes, right. She did lead the fight from 1939 to 1959. She was in the first in the House and then in her last couple of years in the Senate. Yes, she led the fight, and it was her energy again, I think. I mean, it's often the case in the studies of the death penalty that it's a woman who's up front and who has the energy and the drive and the commitment to see the task through to its fruition. And that was Cutler. Certainly others contributed. The League of Women Voters, as you mentioned, held forums and invited others, women who had the right to vote and who were in the law, came in from California and Wyoming and Washington and so on and so on. But it was Cutler who fought the good fight day in and day out in the legislature, thought she had won a number of times, but that elusive goal slipped away. It was close, but she hung in and obviously succeeded finally in 1949-50.
Do you think, I think you mentioned this in your article, that the fact that so many women worked during World War II to help the war effort, do you think that helped them in the...
Yes, that was an argument, one of the arguments. It was added, well, if women can go to war and fly airplanes from here to Hawaii or whatever, wherever they were going to be sent, and worked in the defense system at the time, if women can do all of that, sitting on a jury doesn't seem all that terrifying to them, or indicates that they had the qualities to sit on juries, and men should give up their chauvinism and get with the program.
So Governor Paul Devers signed it into law in 1949.
Yes.
They were eligible in 50, and I think the first women sat on trials or called in 1951.
Yes.
But you said there was one little bit that wasn't cleared up till later, like 1979, something about certain cases that could be embarrassing.
Yes, the way the law came, as Cutler had, it was amended when she pushed it through in 49. And it was amended to read that if a trial contained embarrassing information or lurid detail, then women could be automatically exempted. She didn't like that. She thought that was unnecessary, but in order to get the main part of the bill through, she settled for it and allowed that to happen. Yes, and that wasn't taken out until 1975, finally. And it was the way the law was changed was any person who finds this particular trial or set of facts lurid or embarrassing may request an exemption. It wasn't no longer automatic. And the main point was that it referred to both men and women persons.
So it wasn't until 1975 we truly had a jury of our peers.
Yes, one would say. Yes, though, as I also mentioned, it was 1978, in those years between 75 and 78, it was discovered that the clerk of courts was not exactly doing a great job of choosing women. In fact, he chose every 2 men for every woman to make up the jury pool. And when an end was put to that by the Supreme Court ruling in Taylor v. Louisiana.
Well, we've run out of time. We'd like to thank you at home for watching Jury Duty and Make a Difference on BNN. Just remember, if you have any questions regarding your jury service, you can always go online at majury.gov or call the Office of Jury Commissioner toll-free at 1-800-THE-JURY. That's 1-800-843-5879. You do make a difference. Please serve when called. It's important to all of us. Thank you, Professor Rogers.
Thank you very much.
And thank you at home.